Yes. Not to be deleted.
Please, Milord. 802.
Not to be deleted.
Obliged.
Already there on 29th August.
My lord, early listing of this contempt petition.
What is the urgency in contempt?
This is regarding the abrogation of the Article 370. The Lordship, in the judgment 11/12/2023, directed the Union of India to take steps for the restoration of the Union Territory of Jammu and Kashmir to statehood.
Already listed 10th of October. Not
The early date, my lord.
10th of October. We are already in a midst of a CV.
Grateful, my lord.
Lordship, this is a contempt petition. Lordship has passed a
Yes,
direct.
804.
804.
So called out, you are not there. Yes, proceed.
Your Lordship, it's a early hearing application, Your Lordship. Your Lordship, on 16/5/2023, Your Lordship was pleased to issue notice and granted interim relief of stay, subject to the depositing of the amount by each petitioner within the period of 8 weeks. Till date, they haven't submitted any amount, and the matter is still pending.
17th February 2025 to provide all the financial benefits after getting promotion within 3 months after passing that order. But my lordship, that 3 months is completed on 17th May 2025, but yet order has to be complied by the respondent. So my lord, kindly.
Yes.
Please, my lords, these are the Safai Karamcharis of Jammu Kashmir who had come before your lordships for minimum wages. My lords, in February, the matter was directed to be listed within 3 weeks. I'm only requesting if the date showing was 28th, if it can be listed on 29th, because my lords, on 28th, it won't be taken up because of the reference matter, my lords.
29th to the.
Deeply obliged, my lords.
Lordship requesting for not to be deleted from the call list of.
Yes, not to be deleted. Yes.
Lordship, the petitioner has preferred the writ petition for the constitution of this SIT to prove the extrajudicial killing of her husband and 2 other jail inmates on dated 30.
What do you want?
So, your lordship, the matter may be fixed for hearing and may be decided on merit. No tentative date is showing, your lordship.
28th not to be deleted.
Batch to be heard and listed to be heard separately. But now Vanshakti stands disposed of the detailed judgment, but my matter is not listed at lordship. The building permit is not renewing for want of fees, the medical college, lordship. Maybe listed on next week, lordship.
3 हफ्ते के बाद जिस दिन ग्रीन पेज रहेगा उस दिन.
Lordship, the main matter challenges the virus of the Gangster Act. the main matter challenges the virus of the gangster, UP Gangster Act specifically. Now, the respondent is not filing content in the last 9 months, whereas the trial court is taking the trial on a day-to-day basis. It will
The
render this particular.
constitutionality of the Gangster Act, our counter is gone for signing. It was supposed to be listed tomorrow before my lords, but I think my lords are in the constitution bench. I think they're saying that the trial court is continuing. This is constitutionality of the act. They are seeking a stay on the proceedings. Anyway, they have a no coercive steps order from my lords.
Okay, next. When will you file your counter?
My lords, it's gone for signing today, so it'll be filed by tomorrow, my lords.
Next week,
Next
Monday.
With my lord permission. Your lordships are granted.
No mentioning for seniors.
No, on Friday, your lordships
No,
granted.
no mentioning permitted for seniors.
Lordship said I can mention.
No.
Because that matter.
No.
With my lordship, sorry.
You pay cost, how much?
No, not cost.
No. We have made it clear. How much you are donating to Spora and...
Lordship asked me that mention it on Monday because.
No. We have made it clear that no senior would be permitted to mention.
It was said to me, I was.
Or if you want, then we'll pass a resolution withdrawing the ground so that you can start mentioning from tomorrow.
Then misunderstood, my lords, your lordship.
No. We have made it clear that no senior would be permitted to mention.
I misunderstood, my lord, because what fell from your lordship was mention it on Monday if he's not released on. That's why I came.
No, you could ask this Sharma to mention it. We don't permit any senior counsel to...
It's fine, my lord. I misunderstood since I had appeared in that matter, so I thought.
No. No mentioning for seniors.
No difficulty. Sorry, my lord.
Let there be some scope for junior lawyers.
No difficulty.
So how much cost?
That's your lordship desires, my lord. I cannot.
You pay something to Scora and SCBA on your
Not
own.
to Scora, my lords. We are not very fond of.
Okay, SCBA.
SCBA. There's a big rift nowadays between Scora and SCBA.
Yes, Vishal.
My lord, this order was passed on Friday, where, my lord, you had granted bail. But, my lord, what is happening, even the High Court, where bail was granted on 12th of August, the sureties has not been accepted. And even for the bail, my lord, you had granted on Friday, they're not accepting the sureties. It's pending verification.
My lords, I am applying
My
for the
lord,
respondent listed
still
in this matter. They have not filed any application. As per the instruction I have received, my lords.
My lord, we filed the
If they
application.
file an application, I received an
You direct
document
your
from the-
authorities to...
My lords,
Otherwise, we will issue notice of contempt.
my lords, we have already, my lords, just kindly consider, my lords, sir, we have not received any document for the verification, my lords. If lordship say, then we will release immediately, my lords, without any verification, my lords.
To release him by today evening.
My lords, without verification, my lords, without verification, my lords.
My lord,
My lord, they have not
pending
filed
the
any
order which
application
was passed
for
on 12th of
security
August
documents,
also.
my
They're
lord.
not verifying the sureties in that matter also.
My lords, they have not filed any document for the surety, my lords.
My lord, we've placed the application Saturday. The application is not accepted. We have again placed the application today morning. The judge is
My
not
lord,
sitting.
there
I've
are
been
court
told
duty, my
he'll
lord.
sit at 12 o'clock.
You tell your IO or whoever it is, if he is not released by today evening,
My lords, there is only,
we will issue a contempt notice
my
tomorrow.
lords, there is only one submission, my lords. I'll convey the message, my lords. There is only one message, my lords. My lords, the jailer has to release the petitioners, my lords. My lords, they have not filed any application for the verification, my lords. If we received any document for the surety verification, immediately, my lords, within an hour, we will just conduct the
Give a
surety.
copy to him.
Immediately, my lords, we will
You
conduct.
give a copy of the documents to him. And if he is not released by today evening, we will
My lords,
issue a contempt
my lords,
notice to
my
him.
lords, from our part, my lords, there is no fault, my lords.
You tell your IO that he has to tell the court also that he has to be released today.
If court will pass, my lord, any order, my lords, then we will just give it given a surety orders, my lords.
Give
My lord,
him the copies and if by tomorrow, by today evening he is not released, you will be in deep trouble.
My lords,
Both the FIRs, my lord,
Yes.
because
He has to be out of the jail today.
With my lord permission, my lord.
He has to be out of jail by today evening.
my lords,
Otherwise, your IO will be in jail tomorrow morning.
my lords, definitely he will out of the jail, my lord. That's
Yes,
what
you tell the court also. Okay.
my lord, we already filed and it's order of the court.
Please ensure that he is out today.
my lords, definitely,
Ensure that he is out today, otherwise your IO would be here tomorrow morning.
definitely he will. They will release today. my-
You take the documents and send them by fax.
Correct, my lords.
With my lord permission, may I?
My lord, if there is any issue, I'll mention it tomorrow morning again.
Tomorrow the mention will not be.
My lord, then on
If he has got the message, if he is not released by today evening,
My lords, there is
next, the Friday your IO would be here.
my lords, there is one submission only. My lords,
Don't make any submission now.
my lords, only one submission is requested.
If he observe on the conduct of your state government.
I'm not saying anything, my lords. There is only one submission, my lords. There is a process that the magistrate has to issue a warrant to the jail authority, my lords. If that has been issued to the jail authority, then it will be released immediately in evening hours, my lords.
Ensure that he is released by today evening. We are telling you time and again.
My
If
lord.
you don't understand, then we'll make you understand on Friday.
With my lord's kind, sorry.
And Abhishek Sharma, if next time you get senior to mention, you will be saddled with cost. Yes.
With my lord permission, my lord.
May I
This is a
mention, Lord?
peculiar,
Sorry.
this is a peculiar situation, my lord. I am a victim caveator, my lord. State is not curing the defect more than 6 months, my lord. My lord, the same thing is the accused is a big politician, my lord. They filed only taking the stamp, my lord. Same thing is happened in the earlier SLP also. They are not curing the defect at that time also, my lord. And the SLP was dismissed. And this SLP is also passed the order in July. They are not curing the defect, automatically dismiss the SLP. I am the victim caveator, my lord. The crime against the my lord women, my lord.
Lord, what can we do?
My lord, list this matter, my lord. List this matter, my lord. At least impugn judgment will be
How can we stop dismissal?
impugn judgment can examine by this honorable court. The crime against women, my lord. This is a very peculiar.
Lord's kind permission, may I
My lord,
mention?
this is only one thing, my
The
lord.
listing of a bail application, Lord.
Only one thing, my
The
lord.
matter listed before Justice Amanulah's bench, Your Lordship. There I mentioned on 5th August on account of my son's cancer treatment, Lordship. Lordship directed to list it for 13. 13, the matter was listed in the regular category. I tried to mention before the Honorable Judge. He says since it is not coming in the mentioning list, he will not hear it. And the registrar is not taking the mentioning, saying that matter in the regular category. I'm listing only for the bail application to be
Yes, my lord.
Friday, Lordship.
Fresh petition, my lords, to be listed.
Let the queue.
Oblige, my lord.
I'm mentioning a demolition matter. It was cleared on 30th. It was cleared on 30th. My lords, it has been listed. Your computer date showed of 12th. Again, it got deleted. It is now showing 29. Today, my lords, JCBs are there, my lords.
My lord.
Today JCBs have come.
My lord,
Let there be a queue. To give the precedent listed tomorrow.
With my lord's kind permission, if I may mention this matter, my lord, this is a bench of papers between Lodha and Birla. Now, between the Lodha and Birla over the assets of Mr. MP Birla.
I didn't get you.
My lord, these are matters, a bunch of pending matters before this honorable court. And in a dispute arising from an order passed by the Honorable Calcutta High Court, in a dispute between Lodhas and Birlas, my lord, regarding the will of the lady. Now, my lord, those matters were directed to be listed before the chamber judge on 2nd of September 2024. Till date, my lord, the matter has not come up before the chamber judge, and only.
It should have come through the mentioning process. What is the urgent?
My lord, we already filed an application, and it's a leave granted matter, so therefore I am unable to do anything further except to mention before my lord. This was the last resort.
My lord, mentioning a fresh
Can I?
petition, my lord.
So obliged.
It's a commercial suit where a substantial delay has been condoned by the High Court and the appeal itself has been listed for hearing on this Wednesday, my lords. I'm only requesting the fresh petition may be listed on Friday or on next Monday as.
my lord, this is MSCT petition, my lord. This is a two minor child, my lord. Always delete the matter, my lord. The next day is 15 September, my lord. Kindly not to be deleted this.
My lords, this is a fresh matter. I'm requesting for listing on Friday. I'm requesting for listing on Friday. It's a fresh matter. The urgency in this matter is, my lords, my application for amendment of the suit has been dismissed by the trial court as well as the High Court. Now, my lord, the suit is kept for judgment on the 30th, which is Saturday, and the High Court, the order is still not uploaded, although the case state is showing dismissed. That's why I'm only requesting on Friday, otherwise it will become infructuous.
Friday.
Lord, if I may
Lordship,
mention a matter that
Let
was.
there be a queue. Yes.
Lord, if I may mention a matter that was listed at item 2 on Friday, Lord said issued notice, so I did not press the matter further. Then later the case status is showing that it is dismissed. Lord, I'm just passing on the names of the matter. I don't state it further. Lord,
So we are dismissed. Consciously dismissed. We also said that we don't want I distinctly reiterated, I said that we don't want the court to be a battleground for politicians.
the Lords have dismissed it, I will not press it.
The Lordship,
I distinctly recollect saying that don't permit the courts to be battleground for politicians. Fight your battle before the electorate.
Notice issue.
If you are wrongly heard, we can't help.
Lordship, I would like to mention.
Lord, 30th is the last cut-off date for the farm. These matters are showing in September, my lord. So I am praying for 29th, my lord.
Your Lordship, I would like
permission. These are those matters pertaining to reservation for transgender persons in postgraduate medical education. The results are already out. The matter was listed on 11th of August but could not be taken up. The next date is showing on the 9th of September. But if the counseling begins before that, then the petition will be rendered infructuous. May I pray for a listing on Friday?
Your Lordship, I would like to mention a matter. Your Lordship, the petitioners herein are sitting unemployed because the state of UP failed to give us the. The petitioner are sitting unemployed because the state of UP has failed to give us the EWS reservation criteria which we are eligible for. I request Your Lordship to kindly list this matter on Thursday or Friday this week.
What is the urgency?
Your Lordship, we are sitting unemployed despite being the deserving candidate.
May I with your Lordship?
Lords, I'm seeking listing of two. Urgent stay applications, my lords. The issue is, my lords, High Court holds that MADA is not the competent authority, my lords.
High Court holds?
High Court has held, my lords, that MADA is not the competent authority under Chapter 8. Now, my lords, there are 2 or 3 instances of building collapse recently in August, my lords. We are not able to effectively take steps, my lords, under the Act, my lords. The matter is pending, my lords. One matter was listed before Justice Manoj Mishra. One was listed before Justice Suryakant, my lords. The matter is kept on 16th of September now, my lords. My lords, requesting that the stay application be listed, my lords, tomorrow or day after. My lords, day after tomorrow, my lords, if possible.
Friday.
With my lord's permission, my lords, it's a fresh matter, my lords. Defects have been cured. SLP has been numbered, my lords. SLP has been numbered, my lords. I'm just requesting for Friday. Urgency is this, my lords. I'm a doctor, my lords. I have been wrongfully terminated, my lords, from the post, my lord, without our opportunity of hearing, my lords, without a show cause notice, my lords. 3 years I've been in the post, my lords. Now they've re-advertised the post, my lords.
When were you terminated?
My lords, I was terminated in 2022, my lords, but I filed a writ. Writ, my lords, writ, my lords, they don't hear my application for stay. And they just simply issue notice, my lords. And it's on Saturday, my lords. The hearing is on Saturday, my lords. So I'm just...
May I have my lordships?
My lords, may I please mention, my lords?
Let's do Samaj Parivartana matters, my lords.
1 minute, let me.
My lords, may I please mention, my lords? This is our impleadment application in our Sahara matter, my lords. There are 150 employees who have not been given wages, my lords. And this application is pending since from April 25, my lords. This has not been listed, my lords. These.
May I with your Lordship's
Yes.
May I with your Lordship's indulgence mention a leave granted matter for urgent listing, my lords. My lords, in this notice was issued way back on 21st August 2018. Leave was granted on 24th September 24. In view of the urgency, my lords, by an order dated 13 November 24, your Lordships are directed that the matter be listed on 12 December 24 in the first 5 items. My lords, after that, there has been no listing. I'm only requesting for some date, my lords.
What is the urgency?
My lords, the issue here is, my lords, there was an incentive scheme. I am the respondent in this matter, my lords, and 3 subsidies, they had attained finality, my lords, the issue with respect to 3 subsidies. So, my lords, they had to pay me 129 crores, but because one issue is pending before this honorable court in this matter.
Lords, I appear for the state in this matter. Lords, I appear for the state in this matter that my friend mentioned. It will be in the first week of November instead of October, my lords. I'm just requesting because I'm being led by a senior in that matter. My friend informed me, so I asked.
The Senate is not available in October.
In the first week of October, she's not available. And then after that, last week is anyway, my lords, the Diwali break.
So you want first week of November?
First week of November, my lords. I'll be very happy.
Your Lordship, mentioning a matter, election matter for Chandrapur District Central Cooperative Bank elections. It's being shown on 8th of September. All that I'm requesting is not to be deleted.
Your Lordship, may I mention a matter? It's a 3-judge bench matter. Your Lordship, in January, it was already, an order was passed to place it before the Honorable Chief Justice for getting the matter listed. Thereafter, it was mentioned before Honorable Chief Justice who directed it to be listed in September, in the month of August. But we don't still have a listing date, Your Lordship. The urgency is that it concerns land which were taken by the state under the Sealing Act and now are sought to be returned by the state. So that's the urgency in the matter.
With permission, with your kind permission, I'm seeking an listing for tomorrow. The urgency is that the matter before High Court is on 28th. In a bail matter, the Honorable High Court is asking for documents which are beyond the charge sheet, as well as my lord, he's questioning the investigating officers as to why certain witnesses have not been made. The matter is now listed on 28 before the High Court for final disposal. That's the reason I'm seeking the listing for the SLP tomorrow.
Not tomorrow.
My lords, with
My lords,
permission.
my lords, 28th, my lords.
Friday.
May I mention two Samaj Parivartana matters, my lords, two IAS. My lords, two IAS in the Samaj Parivartana matters, my lords. This is the mining in Karnataka, my lords. My lords, these are, one is a pending IA, my lords, for implementation of direction by this honorable court.
Unless there is a three-judge bench matter, it can't be heard. Yes.
My lords, with
My lords,
permission,
just for
my lords,
listing, my lords.
this is a fresh application in Parsona Charitable Trust, my lords, AICT matter, my lords. AICT, fresh application in Parsona Charitable AICT extension matter, my lord.
Okay.
May I request for Friday, my lords?
In a salt mining matter in Odisha, my lords. In a salt mining matter in Odisha, my lords, there was no effective hearing since April 2024. I am the successful tender allottee, my lords, and I have been waiting
till the disposal of the order of the High Court, my lord. That is why I'm praying that the matter may be listed so that I can pray for interim reading, my lord.
Lords, may I mention one SLP number 12251. The matter was listed on Friday, my lords, in Court 7. The bench is recused from hearing the matter, my lords. I'm requesting a different bench may be assigned, and I'm requesting for an urgent hearing, my lords.
My lords, Advocate AOR, my lords, Advocate AOR Sandeep Deshmukh sir is online on VC wanting to mention, but he's on mute. Kindly he be unmuted.
My apologies for seeking this indulgence. Yes. May I seek your lordship's permission to mention a curative petition for urgent hearing. This pertains to issue of allotment of land for industrial purpose. The auction and allotment in my favor was never under challenge, but what was under challenge is only deposited, because since 1993 till today, and now, my lords, whilst the SLP reached to your lordships from an interim order pertaining to deposit of interest or how much the rate of interest is to be applied, the entire allotment has been cancelled. So, my lords, we have filed a review petition, but it could not get through, my lords. Now it's a curative petition. Now today the urgency is this. Another advertisement is issued for the auction.
They will circulate the curative.
My lords, we have also filed an application for a request for oral hearing, if that can be granted, my lords, so that these things can be brought to your lordship's notice.
We'll see whether oral hearing should be given or not.
Very well. Highly obliged, lordships. Highly obliged.
My lords, in 10-year, 15-year-old car ban case in Delhi NCR, 10-year, 15-year-old car ban case in Delhi NCR, my lords, so you were pleased to issue notice on 12th of August. Similar IAs were also listed on that day, but a notice has been not issued in those IAs. So I request you to please.
They'll be governed by whatever orders will be passing that IA. Why do you want to notice in all the IAs?
In this case, please, my lords. High Court has not yet disposed of the bail application, my lords.
My lords,
in one case, my lords have been pleased to grant bail. But, my lord, what I humbly submit before your lordships, my lord, that your lordship may direct the High Court to dispose of the bail application instead of keeping it pending, and that people are rushing to this honorable court seeking bail, my lords.
My lords,
So if your
for the
lordship so directs, my
co-accused, my lords, the matter was adjourned 27 times. My lords were pleased to grant bail at page 211. In my case, my lords, 43 times the matter has been listed.
The bail matter?
Yes, my lords. I have placed it at page 214.
High Court.
My lords,
And not only in this
therefore,
case,
my
my
lords,
lord,
I'm
in all
equally
cases
placed as the co-accused who, my lords, granted indulgence. And my lords, I have been in prison now, my lords, for more than 3.5 years.
But there are 18 criminal antecedents.
In this case, 2.5 years, 3.5 years otherwise. And in all.
He's a public official.
Yes, but whether he has been granted bail in other matters.
Yes, 211, my lords.
3.5 years.
No, that's correct. What I submit, my lords, that, my lord, instead of your lordships granting bail, your lordship may direct the High Court to dispose of within a week, my lords.
Let us not talk about Allahabad High Court.
No, my lords, I am only, my lord, saying one thing, that, my lord, if in one or two cases, it's my lords exercise the power and grant bail, then it will be flooding this honorable court.
We have granted them liberty to approach this court in the case the trial does not conclude.
I'm not on that, my lord. I'm only that, my
Lord,
lord, High Court,
page
the matter is,
211, it will
the
become
bail
clear,
matter
my
is
lords.
still pending in the High Court, my lord. I only
211.
say that if, my lord, your lordship will grant indulgence, my lord, and grant bail, then the people will not wait in the High Court and they will rush to this honorable court. So, my lord may direct the High Court to dispose of in a week.
11, my lords,
Let it be
co-accused
disposed of
case,
in a
my
week,
lords,
my
has granted bail while the
Instead
matter
of
was
granting
pending.
bail by my lords,
Keeping
High
in
Court
view
may
this
do so, my
issue.
lord. So, my lord may direct the High Court to consider across the country will rush to this honorable court for bail in case there is some delay, my lord, in disposal of the bail
My lords,
application by
I'll show
the High
that
Court.
CBI has been taking adjournments over there, my lords.
Very good.
It happened 21st of August.
This is the co-accused, my lords, has granted.
Grant of bail. The application has been vehemently opposed by the learned ALC on the ground that the petition is pending before the High Court. And it is submitted that if the present application is entertained during the pendency of the application before the High Court, it will set a wrong precedent. Very good. The learned senior counsel of the petition on the contrary relies on the order passed by this court dated 22nd of May 2025. In the case of the co-accused. Very good. So the order passed in SLP number 5480 of 2025. We observed that normally we would not entertain the matter if the application is pending before the High Court. However, in the said matter, we had granted relief taking into consideration that the matter before the High Court was adjourned on 27 occasions. But in the present case, the matter has been adjourned on 47 occasions.
43, my lords.
43 occasions. We do not appreciate the tendency in the High Court to adjourn the matter pertaining to liberty of a citizen on such a large number of dates should be entertained with utmost speed. I have taken into consideration that the petition has been incarcerated for a period of more than 3.5 years.
My lords, yes. But in the FIR, in this FIR, 2.5 years, my lords, otherwise 3.5 years.
So he is remanded in one of the after cases, my lord.
For 3.5 years, including the period undergone in connected matter, we are inclined to allow the application.
Should be released. It may one caveat to the High Courts, my lord. No, my lords, I was saying that lordship may make certain observation.
We have said that it is
to the High Courts, my lord, that they should dispose of expeditiously.
We have been, but how?
My lords have time and again said within 1 month, within 2 months maximum. In fact, my lord said within 2 months, these bail applications should be disposed of.
He should be released.
Yes, next matter.
My lords, if I can pray for being released forthwith if he's not required in any other.
That is the order we have passed normally.
My lords,
So grateful. They have to furnish the bail bonds, my lord, then whether he is required in any other case or.
Next matter is called out.
May it please. My lord, in this, may it please your lordship. My lord, wide annexure P1 at page 10 of this miscellaneous application on 19th of December 2024, your lordship had granted permission to renew the request for bail in case trial is not concluded within a period of 6 months. My lord, now the latest status before the trial court is annexure P4, order dated 18th July 2025. After examining 85 witnesses, the prosecution agency has presented a supplementary challan now, and de novo trial has started.
Yes.
Your lordship, page 16.
I'm appearing on advance notice. May give me week's time. I'll place the entire order sheet. It was on the direction of the Honorable
Okay, issue notice, returnable.
Short date.
2 weeks.
May I please your lordship? Lord, while we have invoked the arbitration and they have without prejudice done, they are questioning the consortium agreement in which the arbitration agreement lies. Now, my lord, in the light of several judgments of my lords, this issue can also, in my respectful submission, be decided by the tribunal, and it cannot have an impediment in coming in the way. Please first have played 34.
Make a preliminary submission which can solve it.
My lord, can I just finish?
Preliminary submission, if you don't mind. There is no original of this document. Let him file an original before the court with an affidavit. Without proceedings under section 9 and going on in the Delhi High Court, where we have said there is no original, the judge has recorded statements of both parties and he seized of the matter. They don't tell your lordship this. So just ask him to file the original blood. I have nothing else to say.
Yeah, my lord, page 34 if my lords
If
don't
there is
mind.
an original blood, it can go.
Page 34.
Yes.
Yes, my lord, clause 11 at page 34 is the arbitration clause, which says all disputes and differences, my lord, shall be referred to arbitration and it shall be 3 members. Now, please have page 36, 11th October 24. My lord, we invoke arbitration and your lordship will see that we appoint, my lord, at page 43, one Mr. Vivek Kapoor, barrister at 39 Essex Chambers. My lord, they respond at page 57, 10th November 24, and raise the point which I already indicated, my lord, at that it's a forged agreement. But please see para 3, last 3 lines.
No, they raise objection what?
My lord, they say that this consortium agreement is a forged.
It doesn't exist.
Forged agreement. Lord, I didn't interrupt my learned friend. But at para 3 at page 58, my lord, kindly see the last 3 lines. After saying it's a forged, be that as it may, if any honorable court directs arbitration proceedings, then we nominate Dr. Bharat Bhushan Prasoon, former judge of the court, as their nominee arbitrator. So I'm only suggesting to my lords a course of action which my lords have followed in several judgments from Maya Swami to the recent.
Where are you reading?
My lord, page 58, 58. This is the reply to the invocation notice dated 10th November 24.
If any honorable court is to direct.
My lord, let him read the entire para 3.
Yes, yes, I'll read the entire
Please read
para
the
3.
entire para.
I started by saying, my lord, they say it's a forged agreement. Kindly see. The present reply is being issued.
So let the issue be decided by the Delhi High Court first. We will consider that.
No, that is only section 9.
So whatever it be, yes. If suppose Delhi High Court comes to a conclusion that the document is a forged document.
But in section 9, they can't. Just let me make my point. This is an international commercial arbitration. We can only approach this court. Section 9 has been invoked by me. In the section 9, they've taken that plea. Your lordship assurance section 9.
So let that section 9 be decided.
There will be no mini trial on this. That has to go to the tribunal. They're having the best of both worlds. There they say don't pass any order because there's no arbitration. When I move arbitration here, they say go to section 9. Section 9 court can't go for appointment of arbitrator. That can only be here. I'm saying, my lord, I'm saying something with greatest of respect and humility, which my lords have followed in a catena of cases. This issue, whether the agreement is forged or not, may be left open for the tribunal to consider even as a preliminary issue. But they cannot, my lord, create a log jam that there is no section 9 moving, no arbitration moving. So having the best of both worlds, defeating it. And consistently, my lord, your lordships have taken that view that if it's a simpliciter case of forgery, as he's saying, then...
Point out.
Yes, my lord. Kindly have, my lord, this judgment. Rashid, my lord, Rashid Raza.
Document exists.
There are several judgments. I'll just place one for my lord's kind consideration. Please have page 62, my lord. 62. My lord, this is the judgment of 3 honorable judges. I'll take my lord straight away, my lord, to the relevant part. Please have, my lord, para 4 at page 64. After noticing, my lord, case of fraud, etc. Para 4 at page 64. The principle laid down in this appeal make a distinction between serious allegations of forgery and fabrication in support of the plea of fraud as opposed to simple allegations. 2 working tests are laid down in para 25. Does this permeate the entire contract and above all the agreement of arbitration rendering it void, or whether the allegations of fraud touch upon the internal affairs of the party having no implication in the public domain? Judged by these 2 tests, it is clear the case falls on the side of simple allegation, as there is no allegation of fraud which would vitiate the partnership deed as a whole, or in particular the
document. There contention is that consortium agreement itself is a fraudulent document.
But greatest of...
It's not as if that there's some allegation which is done to interpolation of a document or something.
Just have para 6 for a minute at next page, 65. This being the case, we are of the view that the disputes raised between the parties are arbitrable and hence a Section 11 application would be maintainable. I'm only recommending, my lord, this is an afterthought which they have taken up. It was signed by those people. This has to be examined. Your lordships in a 11 or a 9 do not have a full-fledged inquiry. It is only a preliminary prima facie view. I am saying, my lord, with full sense of responsibility, somebody has to unravel this. I may be right, I may be wrong.
In this matter,
yes,
at page 62, we don't know what are the allegations. The court doesn't refer to what are the allegations of.
Yes, please have page 63, the first para. The present case arises out of a partnership dispute in which a FIR was lodged by one of the parties alleging siphoning of funds and other business improprieties were committed. The FIR is at present under investigation. Now, please see, my lord, the arbitration petition was filed seeking appointment of an arbitrator, which is to be found in the partnership deed between the parties. Then the allegation of fraud was made. This is exactly why Ayaswamy was cited. And then they say, my lord, that on a preliminary view, it can go to the tribunal to examine this. Your lordships have consistently said that neither 9 or 11 will unravel, my lord, the extent whether it's fraudulent, forgery, etc. Somebody has to have a full-fledged inquiry. No mini trial can be.
The condition is the document itself does not exist.
Substratum, yes.
No, my lord, with that.
And I'll show you,
my lord,
my lord, what exists.
My lord, with
There is
greatest
an
of
admitted
respect,
agreement
that is simply a.
that he doesn't
Lord,
file
can
because there is no arbitration clause.
Lord, can I complete? I am only saying with greatest of respect, that is a plea that they've taken in a reply and filed some FIR, etc. But somebody has to go into it, is what I'm saying. Section 9 court can't go into it.
Then file a suit.
No, but there is a.
I filed a suit also 1 year ago that he is
Milord, I
relying
didn't-
upon a forged,
Milord, I-
forged copy. There is
Milord,
no
it's not.
original.
Milord,
Milord, I beg to appear for spot number 3, Milord. I have denied the agreement entirely, no appointment made.
Milord, can I just make a request?
They are dismissed, yes.
Then can I make one request? Milord, keep this issue open because today the.
We are not intended to entertain the present petition. However, we are not touched upon the merits of the matter. And all issues available to the parties are kept open.
Grateful.
But a similar issue arises in this matter, my lord, in SLP 2165 or 2024, my lord, it's part of your lordship's office report, my lord. And notice was issued, para 4 of your lordship's.
Page?
My lord, office report, para 4. I don't have the page number of the office report, but I have. Office report, Scott Master.
Para 4.
Para 4. Office report, my lord. Sorry, I don't have the page number, my lord.
You are on page number?
My lord, it's even separately, I believe.
Yeah, but that's only the multiplier issue. Other issues are not there in that.
No, we have issued notice in the matters of the landowner, but not of the.
Therefore, the issue, my lord, there are a couple of issues.
It's a question of, it's a multiplier of 2.
My lord, there are a couple of issues in this matter. The first issue is whether the multiplier should be 2. My lord, as far as the state of Chhattisgarh was concerned, my lord, we had a notification of 4th December 2014, which had a multiplicand of 1, my lord. The High Court quashed it. The High Court said it should have a range between 1 and 2. And, my lord, by the time, and that was in 2018, the award came to be passed in 2017. Therefore, according to us, my lord, that would apply. And the subsequent event, my lord, that we passed an act, which was in 2019, where we raised the factor to 2. So therefore, my lord, that is one point. The other point is, my lord, the interest, should it run from 2013 or should it run from 2015 or 2013? Lord? 13. Now, my lord, what we have said is, my lord, the preliminary notification under 11 was only 2015. My lord, on some misreading of the testimony, my lord, they say, well, the barrage was sought to be built in 2011. Please see, my lord, the second paper book. They are still cultivating the land. What the High Court should additional documents, my lord?
Sorry, that document. My lords, I take a very serious objection to the new document being filed for the person.
My lord, the Halka Patwari's report was not called for. My lord, the best thing is don't believe
Is it not covered by both the notifications?
Sorry?
It's not covered by the preliminary notification as well as the final notification.
Yes, my lord, we said.
If you are not taken possession, then you should not have notified it, or you should have withdrawn from the acquisition.
My lord, therefore, my lord, the interest that has been given is given beyond 2015, my lord. The preliminary notification is.
No, the interest is given from which year? From which year?
2013, my lord.
Not from 2013, but 2013 is the preliminary notification is of 2015, my lord. Would my lord just,
Grateful, my lords.
my lord, I was only as far as that.
We have issued notices in the matters of the landowners, not of the state.
State notification, my lord. That notification didn't kick in, which is multiple.
Sorry, you are before a wrong court.
But your lordship may conduct the period then.
May conduct it.
Deeply on that.
May please. An application for appointment of an arbitrator minutes. It's under 11(6) minutes of the Act.
Yes. Issue notice. Returnable 4 weeks. They are appearing.
Returnable notice someday.
I'll see time to find out.
Yes. Returnable 4 weeks. They are very returnable 4 weeks.
Delay can
Some refiling delay.
My lords, this is a case where the rules of the game were changed post the game had already begun.
Why 32?
Yes, my lords.
Why 32?
My lords, in the High Court, a similar writ was already dismissed. Therefore,
That can't be a ground.
my lords, on the exact same grounds, it was dismissed. Therefore, I have come before my lords.
Sorry.
My lords may give me liberty to file 226.
We are not inclined to entertain the present petition. However, the petitioner, the petitioner is disposed of, with liberty to the petitioner to approach the jurisdictional High Court.
Grateful, my lords.
Please, Your Lordship. Your Lordship, in this case, I am the applicant
How
respondent.
can you file such an application in a disposal of
Your Lordship, I just submit. Your Lordship, just 2 minutes, Your Lordship. Your Lordship, in this case, what happened? The petitioner approached on this honorable court and later on withdrew the appeal. Your Lordship, I have stand.
civil appeal was filed by.
That's true, by the appellant, Your Lordship, but he withdrew this case.
So, but how can you?
No, but Your Lordship,
But
just,
give a relief in that matter.
no, Your Lordship, I just see now consequences is this, I could not get anything because proceedings before the National Commission.
How can you dispose of a petition grant?
Your Lordship may direct at least compensation, whatever is the order
Sorry, madam.
given by the National Commission.
Relief got in the by way of an MA cannot be granted in a disposal of appeal. Reject.
Your Lordship may direct the National Commission to consider my application.
You make an application. How can we direct?
Relied upon judgment, Your Lordship, being assailed by the department with regard to maintainability of appeal. That is pending here. Page 64, Your Lordship.
Leave that.
Indeed, Your Lordship.
Check with the matter.
Page 64 is the detail, Your Lordship. Obliged.
Please, my lords. No, sir, I'm seeking a passover, my lords.
No.
Please, my lords.
Lord, item 10, one relief will await your lordship judgment, my lord. Regarding the NRI quota, lordship, I've advised them they have to amend the writ. There are some more documents that you produce. Lordship may have it of 2 weeks.
But you are now.
The state quota, lordship is right. That is to await your lordship judgment, I think.
The NRI also, you don't clear 11th and 12th from, you clear 11th and 12th from Hyderabad.
Yes, my lord.
But you don't reside for 4 years.
Yes, so that is a state quota issue, which hopefully lordship will be convinced and, you know, that I'm not on that, my lord.
Yeah, we don't want to discuss. Come to know on,
is here, so I can't say.
you will come to know on next Monday.
Yes, my lord. So lordship may have it after that. Then NRI quota, I'll advise. NRI quota, there's some more.
You would have come to know on today itself. Then Justice Chandra is out of India. So
Till the judgment comes, we are optimistic, sir. So, lordship may have it up 2 weeks, my lord.
After 2 weeks.
Obliged.
One of this elections of the village committee, which is required under the 6th schedule.
But then why don't you file a contempt before the High Court?
We have done both, and it's still nothing has happened. 5 years, they keep coming and telling the court again and again. This is a constitutional position, my lord.
to implement on the ground. It's equivalent to a municipal corporation.
Issuing notice. Dusty permit over the
Request your password in 12. Requesting your password.
So 13.
Pass over हो गया 1 में. Pass over in 1 हो गया.
Well, 13 arises out of Goa.
Yes, but what is wrong in that?
Plus, can I just show those clauses 5.1 and 5.7? Would your lordships kindly see page 89 for a minute? Because there's something that's startling.
No, this has been set aside by the High Court.
Well, that's 5.7 reservation is set aside by the High Court. Plus, I'll show him, Lords.
And Telangana, in fact, we are recommending that it should be provided this.
I understand. Would your lordship kindly see?
We are issuing notices.
Well, there'll have to be a stay, my lords, because they came after the results are declared. They went to the High Court, my lords. No, that's it. Stay.
And the only reason given by the High Court is that it has been done by executive instructions.
Because 4 army jawans, my lords, so all transfer.
Yeah, but then.
And then completely out.
Yeah, but then Indra Sawhney itself says that the reservation can be provided even by executive instruction. It is not necessary to have a legislature.
Grateful.
In fact, the state of Goa should also have approached.
You're right.
Correction is required, my lords.
Correction of a date.
Yes. Should be 31st August.
The necessary correction. Date of conviction.
I'm so.
For such matters also, why should the seniors come? At least for such matters, you should give an opportunity to the juniors.
If it may please my lords. My lords, on the first round, I approached my lords, had passed an order because I was aggrieved with this interim protection granted for not joining investigation. They moved a quashing against the FIR. On 9/8/2024, a blanket order was passed by the High Court. Thereafter, I approached my lords granted me the liberty to move the earlier listing application. On that, the interim order is passed. My lords, may kindly see paragraph 5, what is the stand of the state? My lords, may clearly see the state has said. My lords, returnable. And thus,
I am appearing for respondent number 1 caveator accepting notice.
Yes, what is this? You give them a tender subcontract on the basis that you have granted a main contract and contract is not awarded to you.
My lord, commercial dispute and my lord under section. They just, my lord, investigation, they want to admit the offences. That's it, my lord. Nothing there. Otherwise, we are cooperating, my lord.
For the 2 people who are in their 70s, my lords, I've appeared twice before the Calcutta police station. All they are saying is please admit to the fact that you have not made the payments. Even after your lordships gave them liberty, my lords, they moved an application for vacation of their interim.
Yeah, this 13.32 crores and 19.19 crores has it been paid by check? By check or by cash?
My lords, it was paid by check, the RTGS amount. I was a subcontractor. My lords, I'm on right now on the procedural aspects. Paragraph 5 of the court records, my lords, of the interim order. The state has said custodial interrogation is required. They have not been appeared. They have accepted notice. Let them place in a.
Let the state come.
Let the state come before the court.
Their application pursuant to your
No, but you don't file an application for anticipatory bail and go directly under 480.
Absolutely no bail has been filed.
Would your lordship kindly see page 103? Even when they page 103 for a minute, lords. This is why a criminal prosecution has been initiated. 103 para 16. Even when they want to vary the interim order, see what the pleadings are. Para 16. Not that an offence is made out. Para 16. 103 para 16. Your applicant states that the applicant has repeatedly contacted the petitioner for payment of outstanding dues. However, petitioner evaded these queries and demonstrated no intention of resolving the matter. Because arbitration clauses there not invoked. Civil suit not done. 2015, they sent me a letter saying that Outstanding dues are there. 2015 is the letter.
Have you filed a suit?
My lords, we haven't. My lords, my instruction.
Then you are just using the criminal machinery for recovery of the amount.
My lords, let them approach. My lords, let them approach and make that statement. My lords, also,
Let them approach whom?
my lords, let them approach before the police and ensure through VC liberty has been granted. Come up and make those statements. Also, my lords may kindly see they are my lords habitual offenders.
Thank you.
My lords, they are habitual offenders. My lords, procedurally,
Highly
no
obliged,
caveat has
my
been
lord.
filed.
Highly
My lords, no caveat has been filed. I was not served a copy. Notice has been granted by my lords. Let them come up before it.
Sorry.
My lords, I wouldn't have insisted.
Dismiss,
My lords, I wouldn't have insisted on the fact. My lords, why don't they come virtually and let the police know about it? Very well, my lords.
Please do not. That's item 16. Your lordships have posted all these matters. It has to come before last week, my lords. Lordships have passed a similar order. This is about the clubbing of FIRs. My lords, let me kindly see the order.
Same order.
Same order. My lords, actually, your lordships have reserved this case, my lords. It has to come last week due to constitution bench. It couldn't come this Friday, my lords, because lordship have.
Just notice track kar dijiye.
Great.
Please, my lords, in item 17, we have filed one amendment application with amended petition. It's an arbitration petition.
Who's anybody appealing for the respondent?
My lords,
You want to amend the petition?
my lords, we have amended the petition. We have filed the amended petition. Kindly issue notice on the amended petition as well as on the application.
Notice for 4 weeks.
Both the applications. Obliged.
Item 18.
As per your last order, my lord, I brought that corrigendum which was issued by the High Court in additional documents. Page 6.
Yes.
My lord will find there's been that in
Page 6.
Page 6.
Page 6 of the application.
Page 6 of the application. Referring to the High Court notification of 28/116.
Page 6 is the last date of the Ajay Institute.
15/7/2000.
Page 8, yes.
Yes.
And then Annexure P8. Yes, proceed.
Yes, my lord. Your lordship will find this notification, corrigendum, they are referring to the notification of High Court 28/116, which has been part of the main SLP. Your lordship will kindly come to that notification of 28/116.
What is your qualification?
My lord, I was higher than 10+2. I was a graduate. But the question is that, as far as these honorable court's direction in Renu's matter, the High Courts were supposed to frame up a statutory rule, which has not been done in Assam. Still it's pending. Now the learned single judge has said, dismissing my review, saying that it has been done by exercising the power under Article 235 and 236, which is my lord, in that case, my interim payer is there. My interim.
How can by an interim order you get?
My lord, because I have already been shunted out at this point, my lord.
Sorry.
Obliged, your lord.
Regarding the vulnerable witness deposition.
Yes, learned attorney, you take it.
I had a joint meeting of at least 4 ministries together and all the DDG, NIC to sit with me. They're working on this, how to develop, because a lot of high courts systems have to be.
After 4 weeks so that the learned attorney.
What I will do is after
I
maybe
just wanted to convey that the whole system has already been designed. It's only the financial aspect that we are.
No, that will also be addressed.
But the learned attorney
Lordship can keep it after 4 weeks, but what I'm saying is that it's already, everything is in readiness. It's just its maintenance because it has to be carried on even after the commission goes, your lordships. This is a module which has to carry on in perpetuity. So that financing is
Exactly, in
required.
fact,
Take the learned attorney over a
Yes,
copy
Your
and can be sorted out.
we'll do all that.
Suggesting a joint meeting, Justice Mittal can meet
In
them.
fact, the government itself wants to take it as one of the most priority items of.
It should be taken because
It should.
you have to restore back the
Yes,
peace. People are willing.
Absolutely.
Learned attorney said that the matter has been put into, and various meetings have also been held. He states that 4 weeks time be granted so that some concrete proposal could be placed before the court.
Lordship, learned attorney was suggesting a joint meeting with Justice Mittal. Lordships may put it as a part of the order.
We are saying that we will leave it to him.
Yes, Your Lordship.
Not necessarily.
No, I'm going to organize it.
He will organize it. Yeah.
Very well, very well.
I'm going to organize it.
Grateful.
Item 20, which is not in the sequence, my lord, but I'll talk to the other side. Lord, this was only for appointment of the presiding arbitrator. We have appointed, I'm seeking time, my lord. We have appointed
20.
Your Lordship need 20. My Lordship need not open the file. It's arising from section 11. We have appointed our respective arbitrators. They have, my lord, sat together and requested us that you seek some time. We will finalize the presiding arbitrator.
Sent a mail last night saying they have appointed somebody. They're only checking his conflict. So if my lords could.
That's exactly what I was.
That's what the. So when do you want?
My lord, after 3 weeks, 2 weeks, 3 weeks.
3 weeks. Yes.
Obliged.
Obliged, my lord.
This is an application for recall, my lords. Recall of the order dated 4th of August, my lords. The petitioner, my lord, is suffering from lung fibrosis, my lord. He is very critical. He is in the ICU, my lord, on ventilator.
How can the order be recalled? If you want, you may file an application on the medical ground. But you are.
If your lordship kindly see the order, my lord, because if your lordship kindly come to page 31, my lord.
But on that day, you made a statement that is in hospital.
There
is no hospital.
No, my lords.
There is no hospital.
There is no. My lords are absolutely right.
Neither doctor nor hospital.
My lords are absolutely right. Well, very unfortunate, but that is the ground, my lords, for this recall, my lords, because the person was staying at home with all these facilities, my lords. If your lordship may kindly see page.
What he is saying is correct.
My lords, he has been having a vacillating stand. Otherwise, his appeal is pending before High Court. Let him move these applications there, my lords. On suspension of sentence, first SLP was dismissed. On review, it was.
How can there be a recall on that in a criminal matter?
And please see the order seeking recall that is recorded as vacillating stand.
If your lordship can present application, however, if the petitioner so desires, may file an application before the High Court
Where his appeal is pending.
for grant of bail on medical grounds.
Please, ma'am.
Then, my lords, then may grant me some relief for 3 weeks so that I may file. I am on ventilator, my lords. I can't surrender. That's the if your lordship may grant me that indulgence, my lords, 3 weeks time to file my application, my lords.
In the meantime, we direct that for a period of 2 weeks, no courses still be taken against the petition.
I'm so grateful, my lords. Grateful.
Indulgence of your lordships. Otherwise, my lords, he was absconding for 10 years after first bail then. But my lords, my lords may say no further applications will be entertained.
We are
Please, my lords.
our CNC, otherwise we dismiss such MAs with costs.
Yes, my lords.
Had he not been so critical, man, I would not approach. Grateful, man.
I filed an application. There is an error in the tender. Your lordships were pleased to deal with this case.
41.
Of additional security and all, my lord, your lordship remember what was scored out. So, my lord, there is an inadvertent error which has happened, which I'll explain. So, my lord, orally, if your lordship remember, my lord, 15%.
If it is less than 15%,
then you had to give.
You have to have the additional performance security, APS.
Which was the difference between my bid and 15%, namely, my lord, I had bid 18.5. So, my lord, lower than 15. So difference of 15 and 18.5 was 330 crores. It was scored out. The High Court said, no, scoring out, my lord, is not appropriate. You have to give. Your lordships were of the view that additional security has to be given. And the benchmark will be mine. That is, my lord, anybody who wants to bid.
Anybody wants to bid, he has to go below it.
Can go below. Now what happened is.
Not can, only if he goes below the.
So then opportunity to Mr. Singhvi's client to go below me, and then he will also give below the APS. As I had volunteered, and he had volunteered in the court, the everybody will give. Now, my lord, an error has crept in, my lord, in the tender. Just see that. Just turn to that.
29.
Just turn to 30.
13.
30. Relevant part.
Caliber is you are for someone else.
Caliber.
So you are for the person who got.
Yes, who was L1, who has been knocked out on the ground, that additional security was not to be given. Now come to page 30. So an error has crept in, and I will explain after I read para 3. My lord, just turn to paragraph 3 at page 30 and keep that difference in view. The floor price or the base price as per SC direction will be 8,277 crores. No problem, that was my bid. And the said floor will also be treated as a reserve for calculation of APS. That is not correct. So, Lord, what it should have been is the APS.
Floor price, base price in view of so and so, will be so and so with GST. And for calculation of APS, it should be the amount below 15%. Difference between.
Correct. So I have corrected, Lord, in my own humble way. I have corrected how the clause should have. Please read. Now, please. So otherwise, what happens is this. So, Lord, if I am 8,277 crores, if the other side bids 278, he will give APS only of 1 crore. The APS has to be of 300 crores. Now look at this, Lord. The floor base price of the Supreme Court direction is 8,277, and the floor price, and that the additional performance security shall be the difference between 85% of the justified cost finalized by the organization.
That's in 4.6. That's in 4.6.
That is not pursuant to clause 4.6. So
No, you are not. You are reading 3. You have to read only what is written.
I'm reading that.
It's not justified. Updated cost, justified cost. Finalized by owner as on the last date of bid submission.
Your lordship's order.
Is right.
The APS will have to be below whatever amount is below 15%.
So, Lord, 15
This is right. He's right.
My friend is right. Mr. Rodgi is right. Your lordship very clearly said clause 4.6. Clause 4.6 talks of the justified cost. They have quoted it at page 7 of the application. So my friend Mr. Rodgi is absolutely right.
You correct the tender document accordingly.
It shall be done, my lord.
Because Lord, the last date is tomorrow. That is why we mentioned to Lord.
Today, you issue the corrigendum today.
My suggestion is, Lord, they should extend it by a week so that people know.
That's right.
When they
That's
correct
correct.
the
Very fair.
Can be done. Can be done. Can be.
I'm for one of the 9 who is also eligible, my lords, technically qualified. We are all supporting this. Your lordship's order was very clear that the reserve price is as per 4.6.
Correct.
And that is what has to be done. So it can't be 15% on 8,000 crores. It has to be 15% on 10,000 crores. No difficulty. We are only saying that this has gone on for so long to today give an APS of 390 odd crores. You will have to give us some time, my lords, only to say within a week we'll do it. At least 2 weeks to give that.
Is not on record.
No, not party, but I'm one of the 9 bidders. I'm one of the 9 bidders. But we need just 2 weeks.
Only be corrected.
At the most, we agree with Mr. Rodgi and
That's right.
Mehta that 1 week period.
All that we are saying is we were not made parties, but we are one
Out
of
of 9, you are 8.
You are not made party because you are not the petitioner before the High Court.
But minus one of the 9 who are eligible as per your
So,
order to bid.
do you submit the bid and
We will. All that we are humbly requesting is if you could get
No.
for that matter.
Lord, only one request, my lord. There is one inadvertent error which has kept in page 18 of your lordship's judgment. Just have a look. It's apparent on the face of the record, my lord. It's a typo. Para 6, page 18, para 6
of the application.
Of the application, my lords. My lord, 10th line from of the successful tenderer. Your lordship gets, my lord. Of the successful tenderer.
From none.
I'm reading that, but first you have to identify the line there.
None of the parties.
None of the parties.
My lord, your lordships have, my lord.
None of the parties,
Yes.
none of the parties.
None of the parties quoting a price below that already quoted, Mr. Rodgi, by the successful tenderer shall be considered. It should, my lord, either it should be above shall be considered or considered should be, should go. Here, my lord,
It should be above, not
it
below.
should be two negatives, my lord, therefore.
None of the participating
That
getting a price
above the already quoted by the successful tenderer shall be considered and the financial bid shall be taken only from those
so it has to be above.
above.
Or it can be not a price better.
Yeah.
Then that is good.
No, above is better. Above better, above stock better.
Sir, the present I has been filed contending that there has been an obvious error in the amendment to the notice dated 21st of August 2025. First one. Correct.
Also, not clause 26, it should be 4.6. I think. Not 23.6, not 26. 23.6.
Where?
I'm sure.
5 lines below that.
It's the same.
Yeah,
It's 23 points.
23.6.
The same parameter last 4 pages.
23.6.
As stipulated in clause 23.
It should be APS.
23 points.
It is submitted that the federal of the order passed by this court clearly shows that if a bid is submitted, which is below 15%,
Not petitioner, my lord, any
if the bid, we are saying,
bid, yes.
if the bid is submitted below 15% of the upset price or the base price, there has to be a justification for such a bidding. It is further submitted as per the order passed by this court. Additional performance security will have to be provided for the difference between the 15% and the bid quoted person. Please, Mehta the Learned, Solicitor General appearing on behalf of the Coal India Limited clearly concedes that the amended notice and error has been kept in the amended notice and the corrected notice in accordance with the order passed by this court would be issued during the course of the day.
Yes.
We further state that 1 week's period would be granted so that the parties get an sufficient opportunity to submit their competitive bids. Paragraph. We find that the proposal made by the Learned SG is fair. It will enable the parties to offer their comments. Well, but it is fair. The parties will get 1 week's time to offer their comment and
No, not offer, my lord, to comply with.
no, they can also, you are going for reverse bid. So all those 9 should be entitled to submit their bid.
Correct.
Yes.
Offer their bids, my lord.
That's what we said. We said submit their bid, so we say offer their.
No, submit it. No.
Submit their bids. Good, so. Right. It stated that there are certain data, but typographical errors in the order dated Swan. It's in paragraph 6. So यहाँ पे correction कर लेना. None of the participants putting a price below की जगह with read as above. और 26 की जगह पे 23.6.
My lord, one more, my lord, thing which we need, my lord, from your lordships, my lord. Process takes about 6 to 7 months. We are at the fag end now. Lord, since now there is an intervention by your lordships and now there is a change. Lord, suppose L1 who bids with enthusiasm and fails to pay the, my lord, this APS, then we will go to L2. We can't have, my lord, 6 more months because every day the country is losing the court.
And if L1 does not comply, his entire security performance amount is forbidden, and that's not a small amount.
Sometimes, my lord, they come and argue that now you you restart the bidding process.
So if somebody says we permit you to file an application.
Kindly, my lord, kindly qualify that, or
Not, we can't.
that if L1 fails, L2 will be granted, no fresh process.
That's a part of the tender process. Why?
That shouldn't be said, my lord.
We don't, we can't anticipate everything that is said.
Lord, just one request, my lord, if your lordship would consider 2 weeks, my lord. 2 weeks, just consider it, my lord, because everybody will get an opportunity, my lord.
Yes, Mr.
Yes, sir.
Instead of 1 week, it says 2 weeks.
That's all, my lord, because the amount involved is such by the time we organize the bank guarantees.
1 week is good enough. If you have money,
2 weeks. Sir.
please. Sir.
It's the Kerala judges, they have all influence of Justice Krishna Iyer. So
Influence of?
Justice Krishna Iyer.
So, yes, sir. Even not understanding pronunciation is difficult. Sometimes I am unable to pronounce.
Naidu was sitting with me at Bombay. Yeah. I used to have some difficulty in understanding the judgment of the court.
Not far more comprehensible than the judge who retired from Punjab.
No, that
was incomprehensible.
No, you can't compare.
No, there is no compare.
I read your lordship's remark. Lord, it was quoted. Lordship Chief Justice's remark was quoted in all.
My Lord Justice Anjaria may perhaps not be aware.
In Karnataka, the lawyers speak English like Kannada.
Lord, there was one honorable judge, now retired. There are 3 orders by this court by different benches that we are unable to understand what is the impugned order. Therefore, matter is remanded.
Including the council. Lord, in that famous judgment, Mr. Krishna Iyer talks about the effects of liquor.
Effects of?
Liquor on a person. So he uses phrases like.
Withdrew also immediately.
Yes, sir, I deleted. I apologize publicly, my lord. After that, an FIR.
Issue notice. Normally, you would not have entered.
Yes, I know, madam. Normally.
Issue notice. Stay of the position.
Grateful, sir. No, stay up.
By identity order, stay of the position.
So grateful, sir.
Thank you.
What is the contempt who is appearing for the Union of India?
It's a contempt of undertaking, which has been given by the ASG, that these vendors who have been who come in the daytime and leaves in the night, they should not be touched,
Yeah, the notice written about 4 weeks.
I appear for the state. There is some merit in what they say. If your lordship comes to page 17 of the paper.
As a policy, the
page
state
17. You know, the last paragraph. You know, the lordship will find the upshot of the discussion, paragraph 27. We are of the opinion the state government committee illegality in withdrawing the ban imposed by the OM dated 24/8/2017. You know, this is at page 191. And after 191, if your lordship will come straight to 231.
Superseded.
231. At 231, that OM of 24/8/17 was withdrawn in October by a speaking order, which is the 231, saying that the High Court recalled its order, which was the base order of 24/8/17, and therefore 24/8.
They are beyond how much area from the Ganga Bank?
Your Honor, I appear for the caveat, Your Honor. I am the original petitioner before the High Court, Your Honor. Your Honor, there are multiple orders of the CPCB, or orders. Your Honor, just brief facts of the case, Your Honor, because it's very important. The High Court never reviewed its order. I'll directly come to the facts on the which have been noted down on the SLP, Your Honor. Your Honor, there.
Let him respond to it.
Yes, Your Honor.
I'll take less than 3 minutes. The point is point C in the middle of the map. It's not a very good map. Yes, and up above that, Raiwala, point B. Now, this is a ban on mining. I am not a miner, I am a stone crusher. I am located
right down at the bottom at D.
Yeah, Patula.
Jayapata. That is 9 kilometers away. Now, possible.
9 kilometers away from the bank of the Ganga River, or?
No, 9 kilometers downstream. And there's a policy of Mr. Rodgi under which he specifies at which point how much distance from Ganga. 1 kilometer, half kilometer, 2 kilometers. I have admittedly complied. This judgment has been written in a mix-up manner for the reason that they think they are banning sand mining. I'm not a miner. And what happens is, there is no ban ever on me. I file an impleadment because I made a foolish thing. The oral observations are made in the court hearing. So I filed an impleadment. On my impleadment, a stone crusher ban is inaugurated in the impugned order. That's the problem. One of the errors the impugned order, Mr. Rodgi has pointed out, that is this reliance on 24.8.17, which is a document superseded at page 231 by 16.10.17. Now, 16.10.17 notes the two orders of the High Court. 24 August, just turn to page 17. Page 17.
No, 24th August 2017
is page 191. It's at page 191.
It is superseded by?
It's superseded by page 231, 16.10.17, which the High Court unfortunately omits to note. Now, there is something more interesting after that. Just see that. 231. And 231 gives your lordships the orders of the High Court, which are quoted.
Where is that 9517 order? From which
Yes, 9517 order is also there.
From which 231 error?
Yes, yes. I'll just show that. Which is the page, 9517. Just show that in a minute, please. Also note, there is a stone crusher policy. Just see that at 266. It gives your lordship Chief Justice's query about distances. 259 at 266. 259. It's an official policy of the state of UP, Uttarakhand, and at 266. This policy is not under challenge.
What are the standards of distance for the application of stone crusher?
Yes.
It begins at?
Begins at 259. Just see relevant one page, 266 and 267.
No, it begins at 260.
Whereas this particular policy is 259.
The governor in the interest of mineral development.
No, yes, that's 260, sorry.
11 November 2021.
Apologies, 260. 260. Relevant is at 260.
259 appears to be a covering letter.
Forget my mistake was not 259. It's not 259. It's 260. At 266 is the question, my lord, the Chief Justice asked. Now, amazingly, this policy is not under challenge. Nobody challenged this policy. Give me that order.
Government what is 100 meters from the bank to the river Ganga, 1 kilometer. For other
different points.
Is your contention that this stone crusher is being run in violation of this?
Your Honor, just a couple of minutes, brief facts and straightforward facts, Your Honor. Page 187, Your Honor. That was the first order of the CPCB under Section 5 of the EP Act, Your Honor. The second point of the directions of the CPCB, Your Honor. In view of the required action needed to stop illegal mining, communicated by the district magistrate.
187.
Page 187, second point, Your Honor. That's specific directions pertaining to the stone crushers, Your Honor.
Yes.
Yes, Your Honor. Now, this is for the closure of stone crushers based on a recommendation of the DM Haridwar, which was captured by the CPCB, and directions under Section 5 were issued, banning stone crushers in the periphery of 5 kilometers from River Ganga. This is the first my submission, Your Honor. The second submission, Your Honor, the Uttarakhand High Court gave categorical directions to implement those directions of the CPCB, wide order dated 3rd May 2017, Your Honor.
Of the required action needed to stop illegal mining.
Yes, Your Honor.
By Haridwar in that issue necessary orders immediately for closure of operation of stone crushers.
Stone crushers, yes, Your Honor. Yes, Your Honor. Now, page 229, Your Honors. Straightforward facts, Your Honor. Yes, Your Honor. Now, on 3rd May 2017, Uttarakhand High Court gave categorical directions to implement the CPCB directions dated 6th December 2016. Post that, these 48 stone crushers who have filed this SLP were closed down pursuant to a contempt petition that was filed after the 3rd May 2017 orders were not complied. Now, after the stone, yes, Your Honor.
Find out from this
Yes, Your Honor. Sure, Your Honor.
229.
229 is the review order which they claim, pursuant to which they claim that they were given permission by the Uttarakhand High Court to reoperate those stone crushers, Your Honor. Now, para 43, Your Honor, I'll directly point out to that. Yes, Your Honor. In such circumstances, I'll just read out that important paragraph, Your Honor, because that's the crux of the matter. Based on that, the illegality was committed. In such circumstances, we are of the clear view that in exercise of the power of review available to us, we should interfere and recall the judgment and restore the writ petition back to file. This is what they claim, that the CPCB directions after this particular review order stands revoked and the Uttarakhand High Court recalled its previous judgment. That is 3rd May 2017 judgment. Now, Your Honor, the second paragraph of the same 43, we have only reviewed our judgment by which we have given a positive direction to the state to implement the directions of the CPCB. There were categorical directions that the Uttarakhand High Court never interfered with the directions of the CPCB that were already in place. Now, Your Honor, the 48 stone crushers that have come in the SLP before this honorable court, they were banned pursuant to this filing of this particular review application. The stone crushers were a party in this particular review application. They were heard and their contentions are recorded, Your Honor. Now, pursuant to this,
Petition was filed by whom?
Your Honor, the review petition was filed by the state, but the stone crushers impleaded and they were made party respondents, as well as their contentions are already on record in this particular judgment, Your Honor.
Where is the 49?
The judgment starts at page 188. The 3rd May 2017 judgment starts at page 188, Your Honor, which is the first direction by the Uttarakhand High Court to implement the directions of the CPCB. On page 191 is the order for closure of stone crushers, which the state complied and submitted before the High Court that they have closed all the stone crushers. And Your Honor, a very important submission. The matter is listed for final hearing on 12th September. This is not, yes, Your Honor, this is an interim order. And other part of the main crux of the matter is, Your Honor, an SLP was also filed before this court on one of the interim orders, and it was dismissed by the Honorable this court, Your Honor. And the other important part is, Your Honor, the judgment of the Uttarakhand High Court confirming the CPCB has been finalized on 5th September 2018, Your Honor. That the judgment has been crystallized. No appeal pertaining to that has been filed. Pursuant to that, NMCG, which is the...
I just want to take...
Sorry.
This order, this order which my learned friend has shown at page 187 is only saying as applicable. As per the policy, that word applicable...
No, not applicable. The CPCB has directly directed all these structures between A point to B point to be stopped.
Just see that for a minute. Very well. Just see that for a minute.
Thank you, Dr.
That order...
Thank you, Dr. Singh.
187.
Thank you. One more.
Well, this is that case of complete systemic failure. SIA is not being allowed to function. Fortunately, now the chairman has come with an affidavit before my lord, and he's given his woes of problems. The senior IS officers, they want to run SIA, my lord. My lord have constituted SIA as a separate body. It's supposed to have a degree of independence.
Yes, who is applying for state of Madhya Pradesh?
State of Madhya Pradesh.
No, you must have an independent power. The CIA has, who is applying for the Union of India? Who is applying for, you are not implemented MOEF.
Yes, we've implemented them, we've written to the...
It's the responsibility of the MOEF to appoint a CIA.
CA has been appointed but made ineffective by the ego problems of the IAS officer. He is a promoted IAS officer coming from deputy collector's cadre. The other IAS officers, they granted 237 clearances without CA meeting. 205 days, no meeting. Means nothing doing, my lord.
You are appealing for whom, Mr.
Respond number 3, my lord. I have been writing letters to them. 50 letters I have written.
You are the chairman of the CA.
Chairman of the CA appointed by the government.
But you are not functioning.
Huh?
They don't permit you to function.
Yes. Even I was not provided a car. My office was locked.
No, but whether the other members of the CA have been constituted?
No.
Yes, there's a member.
Raghuvanshi, they are
the lady member. She's also facing.
All the CA has to be appointed
Yes.
by the MOEF.
Yes.
MOEF.
Where is Mr. Bhatti? Just get her. Have it after 5 minutes.
Yes. No.
Get Ms. Bhatti immediately.
I'll tell her.
This is something serious.
Yes.
Your IAS officers are granting permissions, but taking the law, entire law in your hand. The state is that was the grievance that the state is granting mining permissions even without there being an approval of the CR.
No, don't tell all those things. You are the chairman, be responsible. Don't tell all these things. He is the state.
Mail the statement on oath.
He is your officer.
Yeah, that's not
We should, appreciate his independence. He is not succumbing to the pressure of.
He should not. He should work independently with regard to the entire functioning of the system.
Not at the dictates of senior officers. Otherwise, the very purpose of appointing CR to be an independent body itself is frustrated. Anyway, you get Ms. Bhatti.
From the state is concerned on facts, you have to file the counter or this one.
We get Ms. Bhatti first.
Yes, first we'll get her.
Of an arbitrator, my lords had issued notice on the last date. The arbitration clause is at page 22.
Yes.
Because this is an international commercial arbitration seated in Mumbai.
Yes.
Because we are not objecting, there are only two things, my lords. They can suggest a name, we can suggest.
They have suggested, I think this is.
Yes, they have suggested Justice.
This is Majumdar and this is Anil Menon.
We can suggest one name, my lords may appoint a presiding arbitrator. Because the arbitration clause doesn't say whether it should be sole or three members.
Let it be
three
arbitrator.
members.
My lords may appoint any arbitrator or my lords, whatever my learned friend wants, or my lords can appoint a sole arbitrator.
Sole
any
arbitrator, my lords,
retired judge.
international arbitration, or let it be three.
Leave it up to my.
Lords, it is about $3.6 million US.
25 odd crores, my lords, include my principle of
Let it be 3 members because
we can suggest a name each, my lords. May
suggest one name.
Please, my lords.
From Bombay.
Please, my lords.
You suggest one name.
From Bombay.
And we'll appoint a presiding
Yes,
officer.
that's what. Only thing, my lords, I wanted to point out. My lords may leave all contentions of
Yes, yes.
jurisdiction and merits.
Yes, jurisdiction, limitation, everything, yes.
The limitation and stamping issue amongst other issues.
Stamping, we have already held.
That's why I don't want to raise it here. Also leave all of that open. We'll suggest a name. Also,
ARM Global 3 or 4, what is?
Yes, in the review. They can forward a name. We can.
Are you ready with the name?
Either of Justice Menon or Justice Wazifdar, my lords, any.
Have you spoken to them?
No, I haven't, my lords. So, can my lords have it then?
We'll have it on Monday. Then, what are the names suggested by you?
Justice Ravi Deshpande.
He is from Nagpur, so whether you ask whether he will be willing to come to.
May keep it on Monday. I have taken instructions for client. Let them come with a name. We'll come with a name.
And then you are proposing either Justice Wajibdar or Justice Menon.
Please, my lords.
Ask.
I'll ask.
Ask their willingness.
Please, my lords, I'll ask.
Monday.
And then you ask Mr. Deshpande. I don't mind if he is willing to come from Nagpur to Mumbai.
I'll get back on Monday.
And then presiding officer will appoint.
Yes.
To Justice Bhosle. He can be considered if the retired chief justice, because if there are one of them is a retired chief justice, it is better than the presiding arbitrator is also.
Yes.
Retired chief justice.
As your lordship pleases. We'll come back on
Monday.
Grateful months.
Your Lordship, I am against an judgment of the Honorable High Court of Delhi, my lords, where, my lords,
Service is not.
Lords, they've appeared.
Let service be complete.
You're the complainant. Lords, I am the complainant, I am the respondent in this matter. We filed wakalat. We have filed the wakalatnama, we are ready to argue.
Yes, he is ready, then proceed. What is the matter?
But in this, my lords, a complaint under section 138 of the Negotiable Instrument Act was caused on the basis of a typographical error, my lords, in one paragraph of the notice, my lords, of the demand notice. My lords, may please have my demand notice, which is at page number 28 of this petition, my lords. My lords, the issue that arises over here is, in one paragraph of my demand notice, I have clearly mentioned the check number, the bank from where it was drawn, and also the amount. Now, my lords, in the last paragraph, inadvertently, my lords, as part of a typographical error, I by mistake, the council, my lords, by mistake, noted down mentioned the check amount as ₹2 crores instead of ₹1 crore. My lords, apart from that, my lords, nowhere is this is there a demand of ₹2 crores, my lords. Only on the basis of this typographical error, my lords, my complaint was dismissed. My complaint was quashed, my lords. And also, my lords, this being a penal,